Hello, good afternoon. Thank you everybody for being with us today. My name is Veronica Alvarez and I work for Partners Research Network. And we have with us today Allison Schaberg. She's going to be talking about letters of intent. So thank you, Allison, for being with us today. But before we start, we are going to remind you guys, if you are a recurrent attendee to our webinars about Partner Research Network. If you are new, welcome. And let me remind you guys what we do at Partner Research Network. So Partner Research Network is the parent training and information centers for Texas. We are funded by the Department of Education Office of Special Education to provide free resources and training for parents of children with disabilities and young adults with disabilities that we call them self-advocates. Our mission is to empower and support Texas families and individuals impacted by disabilities or special healthcare needs. Who we serve? Parents of children with disability, youth with disabilities from the ages of 0 to 26. Partners Research Network was first funded in 1986, and now we have 4 projects serving our parents. We have the PATH project, it's in green, the TEAM project, that I'm in that one, is the red area in the map. Then we have the PEN project, and the new one is the PATH project is the green one. That one is in Dallas. The PATH project covers like kind of the Houston area, kind of. And TEAM project, I'm in Austin. So I'm in region 13, and we have also in region 20, we have a new regional coordinator in region 20. That's a good news. She's going to be out working probably in a month. She's still in training, but after a while, we hire someone, yay. And we have in region 1, 2 coordinators. We have Maria Cordero and Rosie Garcia. Our services are free, and we offer parent workshops, youth workshops, webinars, information and referrals, one-on-one technical assistance. We do a lot of support in the R meetings, and we do these IEP clinics to help you understand the paperwork for these kind of meetings and what are your educational rights. We help you navigate the special education process. We do once a year a symposium, and we offer parent leadership training, youth leadership training, and access to social media resources. So for today, your mic and your video is off. So if you have questions, please type it in the chat box or in the Q&A, and we are going to monitor that, and Allison is going to answer those questions. If there is something that we don't know the answer, we will try to reach you out via email in a later date. This webinar is being recorded, and we are going to share it later in this week in our Facebook pages. That's the link. And also Consolidated Planning Group, Allison Schaberg also have a YouTube channel, and she's going to talk about it. And she posted a lot of this webinar also in that YouTube channel. So at the conclusion of this session, you are going to receive a link. This is a survey about an evaluation about this webinar. We appreciate it if you can take your time and fill it. It's 1 or 2 minutes and then we need your honest feedback. And with this, we can report to our grant and continue to give you free trainings and resources. And also, we do not provide CEUs. We do only certificate of attendance. If you need one, just type it in the chat or email me, and I can do one for you if you need one. Again, my name is Veronica Alvarez, and that's my contact information. I also put it in the chat box. And another great information for you guys to know is our webpage. It's a very good webpage. We have a lot of information about disabilities, special education, fact sheet, events, you name it. Please visit www.prntexas.org. So that's the thing that I have to share for you. And now we are going to start our presentation of today with Allison Schaberg. She is a founder and she owns Consolidated Consolidated Planning Group. And she has a lot of experience working with families with special needs. I mean, she's been working for more than 25 years with families. And also she's a financial planner, but also she's a parent of 2 kids with disabilities. And she has a lot of knowledge in a lot of topics. But today she's going to be talking about what is a letter of intent and why do I need one. Welcome, Allison, again.
Thanks, Veronica, for having us back. Welcome, everybody. Glad you're here, spending your lunch hour with us today. And as she said, you know, I am a parent, so I am a professional. I eat, sleep, and breathe this, both personally and professionally. And, you know, and as she said, I have been doing this a long time. Consolidated Planning Group is a holistic special needs planning firm. But a lot of these webinars were really born out of COVID. You know, we had meetings, we had face-to-face meetings. We did live presentations and things like that in the past. And then, you know, obviously COVID hit and the need for information was ever growing, more so than ever. But really, a lot of these webinars were born out of my own frustration of how difficult navigating all of the things as parents that we have to navigate when we have kids with neurodifferences, with challenges, with disabilities, and how everything changes. It's, you know, really a game change when they cross over into adulthood. And so, as she mentioned, and it's in our chat box, we do have a YouTube channel that you can subscribe to for free. There's no cost, and all of our past webinars live out there. We do webinars on a weekly basis on a variety of topics surrounding special needs, you name it, guardianship, special needs trust, you know, SSI benefits and Medicaid waivers. If it's a topic that has crossed your mind, you know, as it relates to special needs and planning, it's probably out there, even ARDs on, like, you know, stuff, you know, for school, educational advocates and things like that. So anyway, check that out, and you can kind of peruse the past webinars for the ones that might be relevant to you and watch it at your convenience. So today, you know, let me just share a little bit more about us from a Consolidated Planning Group perspective. You know, there's even a webinar out there. What is the difference of a special needs planner and a special needs attorney? Because there's a lot of confusion out there in the special needs community of who does what. Like, we get calls all the time saying, hey, I need help with guardianship, or I need a special needs trust. And the attorneys get calls all the time saying, hey, I need to do a future care cost estimate, or maybe I need help with an ABLE account, or, you know, putting protection in place to fund our special needs trust. So what we try to do is we try to explain the difference. Number one, we are on the planning side, the financial planning side for special needs. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy. We are nuanced. Our entire practice is nuanced in special needs. And I, you know, kind of liken that to the idea of, from a medical condition, if you have a medical condition, say with your heart, or if you have cancer or something like that, you go see a specialist, you don't go see a generalist. And I would liken that to the same thing when it comes to a special needs financial planner. Special needs planners are going to make sure that you have money in the right buckets. They're going to make sure that you maintain eligibility for state and federally funded programs for your loved one. They're going to bring your attention to programs that you may have not known about, and kind of give you guidance and kind of handhold on how you need to go about maintaining that eligibility, how you go about applying for benefits that maybe have never been approved before, and how to navigate some of the tricky situations which we run into. I call them the stump the chump situations with the Social Security Administration, and they are endless. So we're able to help on all of those things. So today, what we're talking about is a letter of intent. And why you might need one. And so, you know, when we're talking about a letter of intent, which, first of all, I am going to mention that we have created a letter of intent template. It is a form fillable PDF. And just for attending today, everyone who has registered for this webinar is going to get their own copy of our form fillable PDF of the letter of intent for your own personal use. You can create your own, but this one is already created, and we are going to share that with you today. A letter of intent is really, this is a document I talk about as parents. We have forgot more than anybody will ever know about our loved one. And the point of a letter of intent is being able to communicate the needs of your loved one if you're no longer able to communicate them or no longer here on this earth. And this is important, even as if you're a parent and you're a caregiver, and then the other parent is working outside of the home. What we have found is the parent caregivers sometimes know and manage all of these things, and the other parent manages working outside of the home. So this is just a document, and I would say, that you got to give yourself some grace and time as you're completing your letter of intent, because some of it is looking back on where you've been, where your child has been, and some of it is looking forward on where you foresee them going. But this is just a really an important document. It is especially important if we have loved ones with intellectual disabilities, or maybe they're nonverbal or other things, or maybe they're just young and they have no capacity to understand all of the ins and outs of their overall care. But this document is really going to ensure that your trustee or future guardian knows your child's functional abilities, their routines, their interests, particular likes and dislikes. So sometimes people are going to, ask me, do I really need a letter of intent if I already have a last will and testament, or if I already have a revocable trust, a special needs trust, guardianship, power of attorney, healthcare power of attorney? And so I would say yes, because all of those are legal documents. This document is going to go alongside those documents and provide the particulars. So those other documents are going to provide all the legalese and all the code and everything that needs to be in those legal documents. But this is going to, I use the term get in the weeds as it relates to the specifics of your child. And so we want to make sure that our kids and their future is kind of, when it comes to delivering care and services, that it's delivered in the manner that we would hope as parents. So this is going to communicate a lot of your knowledge, including your specific hopes and desires. It is really a broad spectrum of the things that it covers. And our letter of intent, for instance, it is 20 pages long. So 20 pages form fillable PDF. And so when we're thinking about this, it can be an emotional thing. We have webinars on guardianship, and they talk about the emotional process of filing for guardianship and taking rights away from a child. And I think that, completing a letter of intent can be emotional too, because it is looking back. It is looking forward. It's what was, what wasn't, I don't know, sometimes when you're reflecting on where things have been and where you hope things are going, a lot of times I hear from parents with kids with disabilities of saying we're hopeful and we're optimistic, but we're not there yet, or we haven't arrived yet, or maybe things aren't going as well as you had hoped, and things like that. So that's why it can be a little bit emotional. So if you don't have a letter of intent, I say, give yourself a timeline. Like, maybe I'd like to complete this in 3 months. If you're, extra and you can complete it in 1 weekend, good for you. But you're going to go back and reflect on some things. We're going to start looking at, basic family history, medical history and care. We're going to get down to diagnoses, those dates of diagnoses, who diagnosed what. We're going to have names, address, and phone numbers of all of the doctors that they're seeing, or specialists, when they see them, what they see them for, any details on any government benefits that they may be getting, any SSI, Medicaid, any SSDI or RSDI, and Medicare, living arrangements and accommodations. And those accommodations could be for living arrangements, and also could be for educational. So we're going to have, we're going to list all of the schools that your child has attended. Where have they been, at their employment history, personality, habits, recreation and fitness. You're going to kind of go a little bit deeper about spirituality and values. Who are the legal guardians? Where is the special needs trust? Who did it? Power of attorney for finances, power of attorney for medical. And this is basically anything that you could possibly think of that is related to your child. It could go right down to the county in which that they were born in, the hospital that they were born in. So this is the level of detail that we're putting in there. And so I do see something in the chat box. Today's presentation is being recorded. I always like to say that again, so you don't have to take notes of everything. After later today or tomorrow, you're going to get an email with a copy of today's slides, as well as a recording of the presentation. And then, as I also mentioned, we are also going to include a copy of our letter of intent template that is form fillable, so that way you guys can do this. So again, you don't have to use our letter of intent that's form fillable. You can create your own. But the bottom line is when it comes to a letter of intent, this is something that you create, and then you let loved ones know where they might find this. You share this with the other, for both parents. You might want to share this, or at least share where this document lives for a successor caregiver. If you have a successor guardian or a successor caregiver in place, they may want to know where this is. Some people don't want to share all of this information until they just want to share where their document is, so the future caregiver can find it, because it might contain such things as social security numbers or driver's license numbers or any other identifying information. So some people are kind of cautious on the information that they are sharing with this. But what we don't recommend is that you handwrite this stuff, because we do recommend that you're going to revisit this from time to time. Some of our kids and their diagnoses are pretty static. They don't really change. The deficits they have as a result of those diagnoses don't really change. And then we have other families that their kids and their conditions and their care needs are ever changing. So if you've got ever changing care needs, then we recommend that you revisit this and update it. We always say at least twice a year for everyone, but if things are changing more quickly for you, then you might want to update this a little bit more frequently for that. And again, because this document that we're going to share with you is form fillable, it's a little bit easier to update than to go, recreate it each time. So this is an example of the special needs, letter of intent workbook. I'm going to stop my share just for a second, because I'm going to actually share I think it's going to let me, I hope it will, our actual PDF of our letter of intent, so you can kind of get an example. I hope you guys can see that okay. So this is, as I said, is okay, good. So this is the book. This is the actual copy of the letter of intent that you guys are going to get. And you can kind of just see the general information. It's a lot of information, and you can imagine with 20 pages, we might be getting, stuff like, mother's maiden name. There's all kinds of stuff in here that you're going to get. We're going to grab, relatives and siblings, medical history and care. And, and some of these things can be copied, like if we have, I know that some families have long laundry list of, medical doctors that they see, a long laundry list of diagnoses. Some are more than others. It just depends. But so this is just kind of an example, and because it's a lot, this is why we would say we don't suggest you create it yourself. And you might find something like when you're doing this and you're kind of going through this, something that you might find missing that you want to add. But we also, towards the end, we also have some additional pages where it's basically form fillable, where you can kind of write a story or write what your heart is, as far as your intentions for your child. And we think that is important because sometimes, yes, they need all of the data, But sometimes, you know, there's just that true heart of, you know, what I'm trying to get at, what I want you to know, what is super important. You know, this is, again, I want to say that this is also important. We have nonverbal kids too. We have kids that have meltdowns. You know, detailed information of, you know, what might make a child meltdown and what makes things go smoothly are good things to put in there. Those little things that mom and dad know, right? That other people don't. Those are the important things that you're going to want to get in here. Let me see if this is going to advance now. Okay. Let me see, go back one here. Okay. So when it comes to a letter of intent, again, you know, this is something that you're going to keep together. If you have a will, you have a trust, a special needs trust, your other legal documents, you're going to want to keep this together. You might want to keep it on a flash drive. Maybe you have this magic drawer in your house. You have a file cabinet in your house that you keep important records. This is where you're going to let somebody know where you're keeping this and how to access this in the future. Should you want to. And, you know, for us, we haven't shared this. I mean, I think we have the magic drawer, but we haven't shared this specifically. And I think that that's just a matter of preference on how you want to share. You just got to share that it exists. You don't necessarily have to give it, you know, right now. So, and today's presentation is typically a shorter presentation, but what we're gonna talk about are some things that should be on your radar, and we do have other webinars for each of the topics that we're going to hit on today. So this is just kind of an added bonus for the letter of intent meeting. But when it comes to our loved ones with special needs, there are some real concerns, and you guys already know this. You know, we wear a lot of hats. You know, as parents, as caregivers, as nurses and taxi drivers, you name it, the list goes on and on and on of all the things that we do as parents. But the bottom line is when it comes to our loved ones and our ability and our future ability to care for them, we got to take care of ourselves. A lot of parents are always putting their kids first, or there's not really good balance between, you know, providing care and services for your loved one and providing care and services for yourself. And sometimes that care and service for yourself is just respite. It's just a little enjoyment, a little getaway, a little something for you, you know. But 53% of caregivers said that their own health had worsened due to caregiving and that their declined health affected their ability to provide care. And 55% of caregivers are unaware of how to establish a lifetime financial plan for their special needs dependent. So these are big numbers. And that is a little bit about, you know, where we come in. So we're able, a lot of families come to us. I mean, every week somebody comes to us and they say, I have a special needs loved one and I know that they're going to have care needs for the rest of their life, not just mine. And maybe I've set up a special needs trust, maybe I haven't, but I need to know how much do we need to fund the special needs trust for the future of little Johnny's care? How much do we need to set aside? And this is a big question, and having definitive conversations and getting those definitive calculations together now is going to help make sure that you have that amount in place to fund the trust. It's a big deal that we have in front of us, because as parents, you know, we're going to spend 25 to 35 years in retirement. So that's a lot of savings. That's a lot of money saved up to provide for our future for 25 to 35 years. But what if you have a loved one that's going to likely live 25 to 35 years once you're gone? And so we're able to put those calculations together to show what that looks like. And what does it look like? Does that look like in-home care, assisted living, group home, residential, partial residential? What are the levels of care? And we're able to actually pivot and kind of show the different levels of care, because what we find is as people age, they have less ability to provide for full care needs. So if we have a loved one that has full care needs, when you're 80, you might not be able to do as much as you were doing when you were 60. And when you're 60, you might not be able to do as much as you were when you were 40. And so having that path forward and kind of thinking about what is your vision post high school, maybe they're already out of high school. What we try to do is have some balance. So balance in your life, balance in their life, where they have exposure to others. Maybe they're in a day program, a transition program. There's 18 plus programs. There's all kinds of programs out there that may just be during the day, Monday through Friday. It might just be during the school year. It might be summer programs, but there's a lot of programs out there. So finding balance post high school to where your loved one is just basically not at home all day, every day, with no interaction with others, we do suggest that that is kind of a good path and something to think about. And some of these programs have pretty long waiting lists. So the waiting lists were worse during COVID because, well, it was kind of a double-edged sword. So we had a lot of families that pulled their kids out of programs during COVID because they might have had a compromised immune system and they didn't want them there. And then we had other programs that minimized the number of people that they could have in their programs because of COVID. But the bottom line is some of these waiting lists for any of these programs, whether you're thinking of residential, partial residential, transition programs, or what have you, they can't have a waiting list. So if you're in the kind of transition phase, your child is about to turn 18, they've turned 18, anyway, they're moving into adulthood, be researching some of these things. So what I have here on the screen are things that should be on your special needs planning radar. And the bottom line is we really do have, and we will have upcoming future webinars on all of these topics. So how does it develop a comprehensive special needs care plan? Well, what does that look like? Some people say, I already have a financial advisor. And we always say, hey, that's great. We would be shocked if you didn't. However, and it's not our job to rain on any good planning that you have done in place or already have in place, but most financial advisors don't have any nuance, any background at all as it relates to special needs, as it relates to SSI and other public benefits and maintaining eligibility and how to properly leave money to our loved ones and things like that. And ultimately, our special needs care plan is coming from our budget. So our budget is funding our retirement, and our budget is also funding the trust for our loved ones in the future. So making sure that we have that special needs care plan that ties into your overall financial plan, because remember, you got to spend 25 to 35 years in retirement, so you're funding that as well. It's really important. So it's not just siloed. My financial plan, the special needs care plan, they are kind of siloed, but then they're drawn all together to look at the overall dollars and cents and what it's looking like. So the future care cost estimates, again, those are the things that we can put together specifically tailored to your family and your loved ones and their specific needs, because every family has different care needs for their loved ones, and they have different ideas. I have some families that are clients that say, my loved one is going to live with me until the day I die. And I have a lot of families that say, post high school, I would like, him or her to be in a transition program. And if that goes well, I would love to find an inclusive community, semi-independent living community, a group home, or other areas where they are, they're happy, healthy, they have friends, they have importance because they have a job there. They have, I call it community. They have community. And so every family is different on that. Your future care cost estimate will be different relating to what your thoughts are on that. And you know what? Not everybody even knows the answer of what that looks like for them or what they think that might look like for them. So when we're able to put that together and have those pivot points of, well, what if we do this or what if we do that, that's going to kind of look and impact the overall special needs care plan And so basically it will show you some different doors that you can walk through, maybe you should walk through, what makes more sense financially from a retirement perspective for you to still be able to fund care. We have webinars on Texas waivers and interest lists. We do those fairly regularly. And what I'm speaking of, a lot of times people ask you, is your child on the list? Some families say yes, and some families don't have any idea what they're talking about. What we're talking about here is the Medicaid waivers in the state of Texas. There's a number of them. HCS, Texas Home Living, Community First Choice, the class waiver, MDCP, the yes waiver. There's just a number of waivers in the state of Texas. And unfortunately, in the state of Texas, the waiting list is very, very long. How you get on the waiver interest list is calling your local intellectual disability authority. It is by county. And Veronica, if you could put in the chat box your county. I know Harris Center is for Houston. Texana is for Fort Bend County, and I think we've got Integral Care out your way. Isn't that what it is?
Integral Care is for Travis County, and for Williamson County is Blue Bonnet Trails. Yeah, but
correct.
We can share that in the chat box. Yeah.
So your local authorities, where you're going to get on the HCS, Texas Home Living, Community First Choice, there's a separate phone number for MDCP and class. So some families think that they're on all the lists when actually they're only on the list that the local authority governs. So just know that there is a separate phone number for class, the DBMD, which is the deaf, blind, multiple disabilities, and the MDCP. And there's also even a separate phone number for the Star Plus. So anyway, if you're confused on all of that, go to our YouTube channel. The past waiver webinar lives out there. It has the link in there to find out who your local authority is. And basically you'll put your link in your search bar and put in your zip code, and up will pop up who your local authority is. So just definitely check that out, but make sure you get your child on the list. You don't have to prove eligibility when they get on the list. You have to prove eligibility when they come up on the list. And it is suggested that the waiting list could be anywhere from 15 to 17 years. There are special circumstances for crisis where a crisis waiver spot could be, you could be eligible for. Examples of crisis is the death of a caregiver, major health concerns of a caregiver. The loved one is a threat to themselves or other. They're at risk of being placed outside of their home. There's a lot of different ones that are out there, but the whole point of these waivers is it's designed to waive off the cost of some of the care and services that are necessary for your loved one with special needs. It may pay for respite care. It may pay for attendant services. It pays for a lot of different types of therapy. Basically, if you can think of the therapy, it probably covers it. So even massage therapy, equine therapy, art therapy, PT, OT, speech therapy, just to name a few. So anyway, SSI, SSDI, understanding the differences and knowing when to apply. Basically, all of these topics, again, are all out there on our YouTube channel, and they're probably topics that we could talk about for an hour each, and we typically do. But again, SSI, and Medicaid, the main thing that I want you to know, your key takeaway is if you have a child that is under 18 and they have been denied for SSI and Medicaid, just know that things change when they turn 18. So if you were denied before, SSI is a means-based program, okay? And that means that they're looking at your assets and income. And if they're under age 18, they're looking at the family's household assets and income. Okay. Once they turn 18, even if your child still lives with you, they're looking at the child's assets and income, not yours. So just so you know, when your child turns 18, if they are disabled, you should go about applying again for SSI and Medicaid. Prior to applying, you need to make sure that they do not have more than $2,000 assets in their name, because that's the means-based test. If they do, it'll be denied. If your child has more than $2,000 assets in their name right now, and you're thinking on what can I do with it. The number one thing is, no, you can't hide it. People, well, what if I just move this, or what if I just close this account? So they look back, okay? But what you can do is you can move it into an ABLE account or a special needs trust. So an ABLE account and a special needs trust are the two places that you can have money above and beyond the SSI means-based test and Medicaid tests that will now not count against them for those benefits. So if they have more than $2,000 in their name, basically what you can do is move it to an ABLE account or a special needs trust. We can help you set up an ABLE account. You can also spend it down for their care needs and just have receipts and proof. So if you know they have $5,000, but you're getting ready to put $2,500 down for a procedure or for testing or anything that relates to their care, just have receipts of what you spent it on. So we talk a lot about beneficiary designations, and the reason we talk about that is because about 99% of people have their beneficiaries set up incorrectly on their life insurance and investment accounts. And so what you need to know on this is the bottom line is you should never name your special needs child directly as a beneficiary on anything you have. And the right way to leave money is to the named child's special needs trust. So it would be the special needs trust for little Johnny is the right way to leave money to your special needs child, okay? And the reason we don't want to do this is because if we leave money for our children, they're going to be over the assets test and they're going to lose Medicaid and SSI. So that's why we got to leave money to our kids, to our special needs kids, to a special needs trust to maintain their eligibility for benefits. But the other key thing that I want to talk about here is that on these beneficiary designations, it is also important that you don't name your minor children beneficiaries. And so this is an issue, and it's sometimes an issue in our industry is financial advisors don't know this advice to give people. So when somebody calls and says, I want to change my beneficiary and I'm going to name my child who is a minor, they just say, okay, and they fill out the paperwork. I mean, the insurance companies will let you do it. It's wrong, but they'll let you do it. So why is it wrong? Why? So what a lot of families do, and if you've done this, it's okay, you can fix it. I'm not taking anybody to the woodshed. Like I said, 99% of people do this. So typically what they do on beneficiaries, they name their spouse as the beneficiary, the primary beneficiary. And then they list a contingent beneficiary that basically says, if I die and my spouse is dead and gone, then that's easy. My kids will divide the money equally. And they name their kids outright. So I already explained why we don't want to name a special needs child outright, but why we don't want to name a minor child without special needs outright is because if we do and we die while that child is a minor, then basically what is going to happen is that money is going to sit in trust until they turn 18. And when they turn 18, they're going to get all of the money. So I always say, I know your kids are geniuses and mine are too, but no children. Our adult kids at 18 are capable of handling large sums of money. It'll be gone in a year. It's a bad idea. So the right way to leave money to our kids is to have a trust or a testamentary trust in the confines of your will that spells out how and when they'll get the money, because otherwise they're just going to get it outright. We talk about special needs trusts and how to fund them, but one thing that you guys need to know, because in the state of Texas, if you happen to be divorced, a lot of times child support continues post age 18. Well, when you're applying for SSI and Medicaid, child support is continuing post age 18 for your loved one with special needs. That is going to be kind of deemed against them as income, and their SSI will be either reduced or eliminated as a result of it. But how you can fix that is you can have your child support redirected to a first party special needs trust, and then it will not be counted against them. So if you've got child support post age 18, just know that you need to take action and you need a court order from a judge to get it redirected to a special needs trust. They don't usually deny it. We have a lot of families that just work this out because it's the same amount of money that the other parent is paying. It's just redirected to a first party special needs trust, which you are going to have to pay to set up, pay an attorney to set up for you. I want to just jump back for the beneficiary designations to say that you can fix this yourself. The beneficiary designations, you don't have to hire anybody to do it. All you got to do is check who your beneficiaries are with any life insurance or any investments, and don't forget past 401ks, 403bs, pensions, or other accounts that you may have to check those. But you can just request beneficiary change forms, and then you can get it updated yourself for free once you've got your documents updated. And so what I would say is, in the example that you've got your special needs child named as a beneficiary, and you don't have your special needs trust set up yet, I would say change it immediately. Change it to somebody else temporarily, like if it's the contingent or the beneficiary, your special needs child named outright, change it to somebody else temporarily until you can get your documents straight. Basically, if people leave money to your special needs child directly, you're going to have to hire an attorney, and you're going to have to get a court order to get it moved into a first party special needs trust. And they're, again, not usually denied, but it costs money to get that done. And a first party special needs trust has a Medicaid payback on it. So if you just set it up the right way to a third party special needs trust, then there will be no Medicaid payback at the death of your loved one. Okay, yes. So we had someone say that as for SSI, SSDI, when your child turns 18 and you sign them up, they count the parent's income for the birthday month, but not after that. And I have heard more recently over the last few weeks where they have, I actually had somebody last week that had their SSI appointment, and you're supposed to be able to schedule your SSI appointment for the month that they turn 18. It doesn't have to be actually after their birth date, but they should not be counting the parental income. And I did check with the Social Security Administration on that, and they absolutely should not be counting that parental income when it comes to your child being 18. But in this particular instance, this client was told that because the child was 18 and lived with them, that they took their information, and that is wrong. And like anywhere, the Social Security Administration does have high turnover rate. They have some very, very knowledgeable people that have been down there 25, 30, 40 years even. But they also have a lot of new people, and they don't know everything. The manual for the Social Security Administration is ridiculously huge. Some are trained in SSI and Medicaid. Some are trained in SSDI and other various programs. So it is important to know that. And then also, when and we can consult and talk about kind of best practices for applying for SSI. But what I would say in general is you do need to educate yourself on this, right? There's a lot of information on the Social Security website. And of course, we can help you with this. It is confusing and convoluted, but when you're applying, you got to know what you're applying for and the why behind it. Because I liken it to an order taking system. You call up and you tell them what you're applying for. You call them up and tell them what you're doing. They don't necessarily do this checks and balance to make sure that you're maximizing all your benefits. They don't do checks and balances to say, oh, by the way, you're missing this. Did you know that your child is, eligible to be considered a disabled adult child under a parent's record? They don't always tell you all of these things. So being educated or working with somebody that's kind of got your back on that, I think is very, very important. We say to start touring residential living facilities at age 15. If it is your hope to have your loved one in a intentional living community for individuals with disabilities, there's all kinds of them out there. We have lists with them. Some take waivers, some don't. But we say start touring these facilities at 15. Get yourself on the waiting list. Just because you come up doesn't mean that you have to take it. But some of these waiting lists can be 5 years or longer. So you want to get yourself on the list, and most of them require a tour or an application or something to be on their waiting list. So just check that out. A lot of the tours have started back up. A lot of the tours went virtual because of the pandemic. Some of them are still virtual, so you'll just want to check with them kind of to see what they're looking at. So guardianship, power of attorney, healthcare power of attorney, and supported decision making. Again, we have entire webinars on that topic. That is something that a lot of people have interest in, but in general, guardianship can be applied for 6 months. You can start the process 6 months prior to your loved one turning age 18. Instead of guardianship, there is something called partial guardianship. Instead of partial guardianship, there is healthcare power of attorney, and supported decision making. And as always, just like, you know, working with a special needs planner, we recommend that you work with a special needs attorney. There's a lot of attorneys out there, and they're very smart and they're very educated, but they're educated in their specific you know, law practice in their section of the law that they're working in. So they may not be nuanced in special needs. So work with the specialized attorney. We do have attorney referrals that we know and trust all across the state, that we know that's predominantly what they do. We know that their prices are fair, and that they have, you know, worked well with others all, you know, all across the state. So if you need a referral for that, but that attorney is going to really spend some time with you on what is the most appropriate, the least restrictive and most appropriate for your loved one with special needs. And that's kind of the Texas law, that the least restrictive, most appropriate. So it's not just a slam dunk that everybody's going to get guardianship. As a general rule of thumb, and this isn't a slam dunk either, but if you have a loved one that has an intellectual disability with an IQ score that is, say, 70 or below, in general, it is assumed that they may not have the capacity to understand what they would be signing if they signed a power of attorney, healthcare power of attorney, or supported decision-making agreement. In that regard, they may need partial guardianship or full guardianship, but then they'll go through that whole thing. There's a guardian ad litem that is appointed in this process, and it is a process. There is a certificate that's going to be required to be signed by a doctor. And so, you know, those are just kind of some of the steps. If your child is already over 18, maybe they're way over 18 and you never got guardianship, or somebody never talked to you about this, you can still do that. You just need to work with an attorney to kind of walk you through the process and know what to expect. But just think, you know, for your loved one that is 18 and older, ask yourself, if something happened to you and their other parent today, and they had nobody, could they live alone? Can they manage their financial affairs? Can they manage their medical condition? Can they take their own medicine? You know, what can they do? What can they not do at 18? And that is going to guide some of those decisions, what have you. Okay, so again, you can start that process 6 months prior to turning 18. And so again, we would just say the post-high school education options. We have entire webinars for programs post-high school, college programs, certificate programs, university programs, licensing programs, various programs that are available out there. So you might want to look at that. Not on this list is vocational rehab. Yes, vocational rehab, VR, through the Workforce Commission, the Texas Workforce Commission. Your kids may have a liaison through their school. The public schools mostly have a VR consultant or counselor that is tied to the school. But vocational rehab for our kids with disabilities is, it starts at age 14. From 14 to 22, it's designed to close the gaps on the impediments to employment. So if we have kids with a disability that have an impediment to employment, it's designed to close the gap on those and be able to get them to work, and not just work, but competitive employment. So someone asked, where can we find more information on VR or post-secondary programs? Again, that is going to live on our website, on the YouTube channel that's in the chat box. And again, when you get the recording later and the slides, you'll have our YouTube channel on there as well. So we have entire presentations on vocational rehab And then the post-secondary programs, you can look for the college planning for special needs families. And those are two recordings and presentations that are out there on that. So having said that, I always like to just introduce my team. We work on a collaborative team at Consolidated Planning Group, and so a lot of times I'm the one that's doing the webinars. Michelle does them as well. So I just like to have some pictures, faces with some of the names that you might hear on our team, and we still have 3 others that are not pictured on here as well. We got to get on that. So I keep saying that. Anyway, so as it relates to, planning and your future, where you are, if you don't have a future care cost estimate, you need help with, the Social Security side of the house, we're able to help you. We do free personalized consultations, and you can reach out and kind of talk to us more a little bit about your unique situation and kind of where you are in the planning phase, what help you may need. As nationally certified Social Security advisors, we actually have a specialized software. It is super valuable to you. And the reason why is based off of your Social Security statements, mom and dad's Social Security statements. We're able to plug that all into our system, and our system spits out exactly how and when you should pull the trigger on Social Security benefits to maximize benefits for your entire family. And where this matters is if we have one person that has stayed home most of the career, right? And B, we have one or more than one special needs child in the household. Our kids that are disabled, whose disability started prior to age 22, are able to be covered under a parent's record for Social Security purposes. So if a parent is either retired or disabled, your disabled adult child will be entitled to 50% of the parent's record. So anyway, there's all kinds of specialized calculations that go into the software. It takes into consideration family maximums and things like that. And this is important to you because the rule of thumb is about 80% of families have filed incorrectly for Social Security benefits. This also matters if you're planning on retiring prior to your child turning 18. It also matters. It may not be in your best interest to do that. It's not always the case, but depending on what that 50% amount is will depend on if they'll ever be eligible for Medicaid in the future. So if they're under age 18 when you're filing for Social Security, just know that when you're starting to deal with the Social Security Administration, the truth is it's just complicated. And we can help you navigate that for sure. Veronica, I'm going to turn everything back over to you. Do we have any additional questions or anything that I missed in the chat box?
No, we already covered it. They asked about the slides, and we are going to send a follow-up email with the presentation and with the PDF of the letter of intent that you promised them. And you answered the question about the SSI. I don't see any more questions in the VR question. So thank you so much, everybody, for being with us today. And thank you, Allison, again, for being with us and sharing all your knowledge and all these important topics. And please reach out for the next one. And thank you so much.
Thank you. My pleasure. Have a good one, everyone.
Bye. Stop the